This is American Government on Friday, November 13th, 2020. Today we're discussing the judiciary, and we're examining the contemporary controversies about the nature and scope of judicial review, which is the main issue in some ways in our with respect to the functioning of the judiciary. This controversy takes place within a certain universe of vocabulary. You often hear of liberal and conservative judges on the court or on the judiciary, or activist and restraintist, or originalist and living constitutionalist as the alternatives. I think of these pairs, in some ways, as we'll see when we look in a bit at William Brennan and Robert Bork. William Brennan was one of the longest serving justices on the court, and part of the period of Warren Court and post-Warren Court activism that's discussed in the Wilson chapter. Robert Bork, of course, was President Reagan's nominee for Supreme Court Justice who was rejected by the Senate, and many people date the acrimonious and ideological debates in the Senate over the ratification of presidential nominations to this rancorous debate. And in the last couple of years, we've seen the potential for partisan rancor that judicial nominations has generated. And what I hope to do in today's discussion is to suggest what the source of those ideological positions is and why some people have such intense passions about this question. I think the least satisfactory language of these pairs of adjectives to describe judicial philosophy or orientation is liberal conservative. Although there's no question that to some degree there's been a partisanization of this ideological orientation on the court and I do think, as you'll see, restraint activist, living constitutionalist, and restraintist, originalist, I do think those pairs of adjectives are useful and descriptive in terms of understanding a judge's understanding of his or her function as a judge. Liberal conservative is an attempt, I think, to put within external partisan categories the differences on the court. Now, what supports that is the fact that the restraintist the activist living constitutionalist position represented by Brennan has come to, let me see if I can say this in English, has come to be adopted by the Democratic Party, and the originalist and restraintist orientation of judicial philosophy has come to be adopted by the Republican Party. And so there is a kind of partisanization of these judicial philosophies. And even the Wilson text uses liberal and conservative to describe the justices on the court and differentiate between them. But I think this is part of the shallowness of our journalistic and to some degree political universe, that we use these partisan terms as like liberal progressive versus conservative capitalist. I think they're ultimately unsatisfactory. Now, you still have to explain why these orientations of judicial philosophy, such as restraintism or originalism and activism or liberal living constitutionalism, have become partisanized. I think that's a complex question. I'm not sure I fully understand it myself. But that's what we're exploring today. And Wilson, in chapter 12, has a useful discussion of, I call this in my notes, different constitutional orientations on the Supreme Court over history. And I think those are useful categories, as you'll see. There are essentially 3.5, maybe 4 periods that he discusses. I'm not sure they have to do so much with orientations within the court, but rather the kinds of issues that were facing the nation. Although to some degree, it's not just a question of what issues were facing the nation, but how the court responded to them and adopted a consistent jurisprudence. I think it is fair to say that in each of these historical periods of Supreme Court functioning, there was a consistent Jewish jurisprudential um, jurisprudential orientation that you could describe, and I think Wilson does as good a job as any describing that. Let's cover those. Um, Wilson suggests that the first great period of the judiciary, from about the founding to about the Civil War, dealt with issues of the expansion of the national government, some issues of the supremacy of the national government over the states, confirming the scope and authority of the national government in the constitutional system, and of course, slavery. Well, it makes sense. I mean, in this course, we've looked at several important court cases like McCulloch v. Maryland, which is probably the chief case. In fact, he discusses it in this section, that confirmed the supremacy of the national government over the states, and an expansive version. He also discusses another important Marshall opinion, Chief Justice Thurgood Marshall during this period, Gibbons v. Ogden in 1833. So, and of course, probably the single most infamous Supreme Court decision of all time that we've talked about, Dred Scott v. Sanford in 1857, dealt with slavery. But to some degree, that's because the issues of the solidity, supremacy, expansion, consolidation of the national government's powers, and the issue of slavery were the issues the nation faced in that first third of our history. The second one begins with the Civil War, because Wilson suggests, and I think he's probably correct about this, that by the time of the Civil War, well, the Civil War was the war between the states, as Southerners like to call it, and to some degree, the defeat of the Confederacy by the Union did confirm and expand no doubt through blood and struggle, the orientation of the Supreme Court to uphold the growth and power of the national government. So it's true, then you could say, with that issue settled in our life, to some degree anyway, from about the end of the Civil War, about 1870 to about 1937, and here you'll see there's a fairly specific date, because this does have to do with a consistent approach to jurisprudence on the Supreme Court. That was the economic jurisprudence. And by the way, if you go back to Chapter 3 on federalism, this is the period that Wilson discusses as dual federalism. And to some degree, there's some accuracy in that it seemed as if what the Supreme Court was trying to protect during this time, and what was the issue, what was the state of the nation during this time? Well, during this time, national capitalism grew, corporate capitalism. The economy grew from local economies to much more integrated and national economies, and even international economy, as has continued in our day. And to some degree, the Supreme Court seemed to want to frustrate attempts both on the national level through finding limits within the Commerce Clause to Congress's regulatory power, and on the state level through the Due Process Clause to protect businesses against attempts to regulate and for social welfare legislation. There's some truth to that, and you could say it did reach a peak during the Depression and the New Deal. After 1932, when President Roosevelt, FDR, was elected, the whole the overwhelmingly Democratic Congress and the Democratic president engineered a whole series of attempts to pull and steer the country out of the Depression. And it's true that the Supreme Court did routinely declare unconstitutional those attempts to extend national power. And this was, of course, the occasion of the infamous and controversial court packing plan, a term which became controversial in our own day, with the nomination and approval of Amy Coney Barrett to the court. But there was a certain sense in which the Supreme Court seemed to sense that, even though, by the way, FDR's attempt to pack the court by putting a retirement limit on the sitting justices, or by expanding the number of the court so that he could have more of his appointees that would support his jurisprudentially, his attempts to negotiate the New Deal, it turns out that was not necessary anyway, because one of the justices on the court, seeing perhaps the threat to the court, exactly changed his vote in 1937, late 36, early 37, and began to vote with the minority, the Rooseveltian minority, and support the New Deal. And in our jurisprudence, that's sometimes called the switch in time that saved nine. And then I have to explain to my students what that's a reference to an old saying, a stitch in time saves nine. A stitch in time saves nine because of darning socks. If you darn socks, and you know what darning socks is, some of you will know that. So the aphorism applied to the Supreme Court is the switch in time that saved nine. That saved the 9-person court. But nevertheless, the court became quite explicit that it was going to turn away from attempting to negotiate limits to national power in the name of the Commerce Clause and switch to new orientation. And this is quite accurate to say that the court deliberately turned to the question of personal rights and political liberties. And that has been its orientation primary since then. And as Wilson describes, that became most evident and controversial in our national life when President Eisenhower selected Earl Warren, who is a federal justice and had been the Republican governor of California, as the Chief Justice, but then who turned around, and this, by the way, is a caution to presidents thinking they can control the judiciary, because eventually the Warren Court over the next 20 years expanded, became a time of immense judicial activism, and that living constitution theory dominated in some of the most famous and infamous and influential cases. Brown v. Board of Education, Engel v. Vitale, that declared unconstitutional state-sponsored school prayer, Miranda v. Arizona with the police warnings that you have to have a lawyer and everything like that. Very consequential decisions that profoundly affected the present and the future of the American Republic. And Eisenhower actually at one point said Earl Warren was the biggest damn mistake I ever made. So again, a caution to presidents who think that you can simply control the direction of the court by your appointees. You have to remember, as Hamilton predicted in Federalist 78, that these are lifelong appointments, and once you become a member of a separate and equal branch of government, there's no necessary connection, and many justices from both appointed by Republicans and Democrats have gone in directions that the presidents who appointed them, or the Senate who confirmed them or opposed them for that matter, could ever have imagined. If you're serving on the court for 30 years, you may change your mind about many of these questions too, in ways that even you couldn't predict. So the last kind of orientation that Wilson discusses since the 1990s, there's been the issue of the court, and somewhat this might be because of Republican conservative appointees, presidents, and that is a kind of a resurrection of an attention to state sovereignty and the integrity of the states and semi-sovereignty of the states within the system. In the 1990s, the court invalidated some congressional legislation based on an overextension of federal power. This is sometimes called 10th Amendment jurisprudence. But generally speaking, I think, as I said earlier, although these periods may describe long-term orientations about how to interpret the Constitution and apply it on the court, they are as much responses to larger changes in the nation and issues facing the nation. So let's turn to the Great Controversy. And as you'll see, as I've pointed out from our lecture on the framers' intention of the judiciary with respect to judicial review and Marbury v. Madison, the controversy in our political system today is not whether or not the court has this implied power. That's been pretty settled since Marbury v. Madison. The great controversy is what is meant by that power, how judges use that power, and what's the scope and limits of that power. And it's almost as if we now ask two guest speakers to represent these two orientations. To summarize the nature of the controversy and to make the case for their understanding of judicial review and the proper role of the court. As I already described who these two individuals were, William Brennan, who at this point is the longest serving justice on the court, 42 years, I believe, and Robert Bork, who was unsuccessfully nominated by President Reagan as a Chief Justice. And as we'll see, these two great individuals both share some assumptions. I'll try to point those out. And some they do agree on some things. Probably like many Americans in political disagreements. After all, we do share a common universe of principled ideas that from the Declaration. We do share a common history, and both of these judges and jurists are devoted to the role and importance of the court. So it would be probably more surprising that they don't agree on some things, and I'll try to again suggest what that is. But then they also do provide very, very different understandings of what the standards of judicial a decision should be, and what the role and nature of what the nature of judicial review is, and what its scope and limits are, and what the role of the Supreme Court in American life is in the constitutional system. What they share is an understanding that judicial review, as we've come to understand it, the power of the courts to declare unconstitutional the laws of Congress, the actions of the president, or the policies and actions of the states, is a problem in a Republican or Democratic system of government. Both of them share a certain understanding of the tension that the judges are, in fact, unelected. They are, in fact, appointed for life. So, in some ways, whereas the other two branches of government in the states in general are political in the sense, and this is, by the way, Hamilton originated this distinction in Federal 78. The other two branches of government are political, or called political sometimes in our constitutional system, because they have to run for office. You have to mount political arguments to get elected to Congress and to be elected to the presidency. So, but nevertheless, there's some direct, or even with the Electoral College. Remember, both the House and Senate are now popularly elected directly by the people, and even if you see if you followed our discussions of the Electoral College is no longer not a popular body. To follow Diamond's argument from his defense of the Electoral College, rather, what the Electoral College does is register the popular vote on the state level, but it's still a popular body. So these two bodies are political in the sense that they are directly responsible to the American people, and therefore electing and then standing for re-election gives some kind of accountability to the people, because after all, the opening lines of the Constitution, I should not surprise you, are we the people. And so the court, on the other hand, is appointed and serves for life. So to give an unelected and lifelong a body the power to negate the laws of the people would seem to introduce a real tension within the system. Now, that goes back to the beginning of the judiciary, and Hamilton said there's some truth to that. Even Hamilton agrees with this. But his argument is what justifies the courts having this extraordinary authority is their special role in maintaining the limits of a limited constitution in limited government. And there's no question, and we'll see this is important to both Brennan and Bork. Even though we are a majoritarian system, by the way, let me back up one second to say the second sense in which the legislature and the executive branch are political, not just that they're directly accountable to the people, and they're political in the sense of having to mount a argument to the people for their elevation to office and continuation in office, but they make policy. It's the business of these popularly elected branches responsible to the people to steer the nation in its public policy. And as we saw, the one real quote from the Constitutional Convention, and which is reflected in Hamilton's notion that the judiciary is the least dangerous branch because it has neither the power of the purse, which Congress has, nor the power of the sword, which the executive branch has, but simply judgment, which is to say application of the Constitution. So if you remember, the one quote from Elbridge Gerry in the Constitutional Convention said, when he was defending the idea, or rejecting the idea of a council of revision that would combine both the executive and the judicial branches as an exterior restraint to the Congress, he said, you don't need it. The president will have the veto, and the judges will have the power to declare laws unconstitutional, and as opposed to making policy. So in some ways, we've always made this distinction between the exercise of legislative and executive power, which are policy making, that the judges don't make policy. They're not policy making branches. Their function is to adjudicate individual cases and controversies that arise under the Constitution and national laws and policies, and in some ways to maintain the constitutional system through its power to negate the other branches. That's the whole rationale for judicial review that Hamilton makes in Federal 78 and that Marshall makes in Marbury v. Madison. So, as you're going to see, nobody denies that the decisions of the Supreme Court when they interpret the Constitution affect policy. But one of the controversies between these two great jurists and these two opinions is the extent to which the court should be an active policy maker. And that those issues have arisen in judicial confirmation controversies also. So both Bork and Brennan agree that there is a tension between the court possessing this power to negate the actions of the other branches in a popular system of government, a Republican system of government. And by the way, one other note that remember Hamilton says some people think that giving the judges this power elevates the judges over the other branches. Because the role of the judges in the Article 6 supremacy issue is clear within the Constitution. But according to the constitutional theory of separation of powers and checks and balances, the three branches of the national government are separate and equal branches. And so both, in addition to seeing the tension between the exercise of this power and with popular republicanism, and also the tension between the judiciary being an equal branch among others, that leads to both of them understanding that you have to mount a justificatory argument to justify the use of this power and the judges having it. And that is what both of them try to do in their different views of constitutional interpretation and judicial review. The other interesting area of agreement, which may not be evident on the surface, is both argue that the nation changes over time, that historical circumstances provide challenges to maintaining the constitutional system, and that therefore the Constitution has to be updated. After all, when the framers created the Constitution, the nation was not a global superpower. Nuclear weapons didn't exist, computers didn't exist, the internet didn't exist, telephones didn't exist, and so we live in a different world than the framers lived in. Both judges are aware of that and believe that the Constitution was, as Marshall says in McCulloch v. Maryland, if you remember, the Constitution is meant to endure for the ages, and therefore there has to be some flexibility in the constitutional system as his history evolves. But let me say that in this respect, these two judges also believe that part of the court's task is to pay attention to those historical changes and developments. Although here, as you'll see, their very commonality leads to a difference of opinion among them. Because I would say that, to put this debate very crudely, to some degree, Brennan believes that there's something like historical progress and that the human race is moving forward in moral and political progress. And the nation today, well, and there's some obviously who can deny that. When the nation was founded, slavery was a part of the political system and economic system, and we eventually reformed that out. There's no question that in many ways the nation, the human race perhaps, but the American nation has made progress in many ways. The franchise has been expanded. And the people participate more directly in political processes than the framers ever could have imagined. So the world we live in isn't the same world, both in terms of technology, historical developments, the size and scope of the nation, and perhaps even moral progress to some degree. But here I do think that there is an important difference of opinion between Brennan and Bork, because and the difference although they both agree that part of the function of the court is to adjust and update aspects of the Constitution to meet new circumstances and historical changes, I think Brennan is much more convinced that the American people, that the human race has made moral progress, and that part of the task of the court is to reflect that moral progress. I'll try to use as a specific issue, still a very controversial issue in the public sphere, and that's the question of capital punishment, of the death penalty. And we'll come back to that in discussing some questions that I would ask if they were literally if I was interviewing them and they were having a debate or a conversation with me in front of them. What questions would I ask them? We'll come back to this because I think this is a good issue to see their differences. So, to some degree, to put it very crudely, even though both agree that part of the task is through constitutional interpretation is to keep the Constitution current with changing times. This is very crudely put. There's a certain sense in which Brennan argues that constitutional principles have to be updated, and that to reflect the moral progress of the nation and the American people. For Bork, I think Bork would say that's an overstatement and exaggeration, and is finally it expands the function of the judiciary too much, because the task is not to, through interpretation, find new principles in the Constitution, but rather to update existing principles. That's very crudely put, but I think it may be usefully put, that at the heart of these two orientations, the one says that judges have to read morally progressive new principles into the Constitution, say on capital punishment, that now as a nation we know better than they did then, versus the originalist orientation and restraintist orientation of Bork, who says, well, the judges, it's not their point to make policy and update the Constitution in that sense of finding new principles under old constitutional language, but rather to find new interpretations of existing principles, to apply old principles in new ways rather than find new principles. Again, as I say, that's very simply put, but that captures something of the difference between them. So let's look first at Brennan, and then we'll look at Bork, and then I'll pose questions for both, and then we'll turn to the question of what are and Wilson has a good discussion at the end of chapter 12. What are the actual checks and balances and limits of judicial power in our constitutional system? And there are some. I think Brennan says the problem is the Constitution is not always clear, and it's ambiguous, and therefore when judges apply the Constitution as a standard, what's necessary is interpretation. So, and by the way, Bork wouldn't deny that. So again, to see their similarity and differences, they both agree that the task of the judges isn't to interpret the Constitution. The question is, in the light of what and how do they interpret it? Brennan expressly criticizes the originalist or original intention position that Bork supports. And in fact, I think he makes two kinds of criticisms, however, both of which are pretty sharp. One, he calls it a kind of false idea, a false position. He actually calls it arrogance cloaked as humility, because the reason he rejects this opinion, he says those judges who hold this say their task is not to make policy, it's to keep the framers' intention relevant by using the framers' intention as a limit to the other two branches in government in the states. So, my mother's cat Tuffy is meowing in the background. He goes crazy at night and starts to shriek as if somebody was setting his hair on fire. So do I, but we're all safe. Anyway, so Brennan says that this idea to be guided by the intention of the framers is both arrogance cloaked as humility. I want to come back to that because I think he's not fully consistent about that. And he argues it's impossible because we can't know what the framers meant. They had conflicting opinions. There were debates, and we've seen that. There's some truth to this, by the way, that for instance, with respect to the nature and powers of the presidency, that two great founders, probably the brightest founders, most brilliant founders, Hamilton and Madison, did have different opinions. So there's truth to this opinion, to this notion that the intention of the founders isn't always so clear. And then this is the somewhat sharp suggestion that Brennan makes, is that those judges who claim that all they're doing is discovering the opinion of the framers, is all they're doing is dressing up their own policy preferences in the pious clothing of original intention. So Brennan, I think, thinks he's doing something in this article sort of like in The Wizard of Oz, pay no attention to that man behind the curtain, that he's pulling the curtain away from those judges who claim not to be making policy, but rather just upholding the ideas of the framers. He thinks that's actually arrogance, and he thinks it's impossible. We can't know the intention of the framers. They're dead anyway. And I actually had a constitutional law professor who, in maintaining this position, made exactly that statement. The framers are dead. Who cares what they thought? But I do think that Brennan does believe that, like it or not, you're a policymaker as a Supreme Court justice, and so you might as well be honest about it. And that's where we come to what he understands interpretation to be. So I think that his understanding is that the great principles of the Constitution, especially what he sees to be the foundational principles of the Constitution, taken over from the Declaration, is equal human dignity, the equality and dignity of every human being. And that therefore the judges, and this is complicated, because this is what justifies in Brennan's eyes the court using its non-popular authority to overturn the will of majorities, Republican or Democratic majorities. I don't mean the parties, I mean a Republican system of government or a Democratic or popular system of government. That in some ways the task of the judges is to take the enduring principles of the Constitution and expand their scope and create a better and more just country. The image that I used to describe this, I had to squirt the cat with my parents' cat enforcer, which is a squirt gun that squirts water. That's how they get them off the table, etc. So if you hear this cat shrieking in the background, it's not because somebody's conducting medical experiments on him or setting his hair on fire. He just likes to go crazy at night and shout to the heavens. Anyway, I think the image is of what the function and nature of the court is for the court to expand as a kind of a pilot to the nation the notion of human dignity, and to expand it to as many people and situations as possible. So there is a certain sense in which the image of the pilot of a ship, at least with respect to Constitution's core principles, there is a certain sense in which I think that captures something about what Brennan thinks the role of the judiciary is. I'll come back to the question of capital punishment, and I'll talk about an important case that the court decided, and then eventually overturned, by the way, in 1972 about capital punishment, and you'll see what I mean by this image. So for Judge Bork, the court is not so much the pilot of the nation, the moral pilot of the nation, as the constitutional check on inappropriate policy and majoritarianism when it strays from the channels that the Constitution, as limited government, has embraced, as Marshall suggests in McCulloch and Marbury v. Madison. I'm about to resort to the enforcer again. That worked. I'm going to pause while he gets this out of his system. I think I've silenced him anyway. For Bork, the judges do have to sometimes limit the other branches of government and popular majorities, but only when they stray from the original purposes of the In in Bork's language, the purpose of the judge is not to make policy, it's to find law. They don't make law. The legislature makes law, and therefore the judges must restrain themselves in the use of judicial review and only employ it when a clear constitutional limit has been reached, because we are a republican or popular system of government. And therefore, Bork argues that this expansive view of jurisprudence that Brennan is articulating does, in fact, make the judge, the Supreme Court, it turns judicial review into judicial governance. And Bork argues only if the judges are embracing the intention of the framers or the principles of the framers does that justify the judges having this extraordinary authority in our system. So his philosophy of judging is to look for the intention or principle behind the legislator who makes the law, whether that legislator is the American people through the founding, and even the legislators passing statutes. So in some ways, the reason that the intention of the framers or the principles of the framers, when clearly articulated and interpreted, the reason that's the guide for the judge is it's actually the people speaking through the Constitution. And therefore, you have to apply the Constitution that way it was adopted at the time of its adoption, even though you take into account ambiguous phrases in the Constitution and differences of opinion. Your task is not to tell the people the way they should live or how they should live as a nation or to direct them. The task is to say no to them when they exceed the grants of authority or the principles of the Constitution. That, I think, lays out their fundamental differences of opinion. And if I were interviewing them, or if I was the moderator of a debate between them, here's what I would ask them. This is the two questions I would ask, or the questions I would ask of Brennan would be something like this. Brennan states that a judge states that the idea that a judge can discern the intentions of the framers is, quote, and this is a quote again, on page 370, arrogance cloaked in humility. But isn't it? But then his argument is what the court's doing is sensing the moral evolution of the American people. Isn't that arrogance cloaked in humility, that you, this unelected judge, sitting on the Supreme Court, that you know what the American people think and need, and that you become the sort of oracle or prophet of moral progress where the nation is or should be, or where you think it should be? I'm not sure that's any less arrogant than thinking that you can understand the framers' intention. Again, you could say that the president of the Congress have a better claim to that because they're actually elected by the people, and the political debates that they have are actually rooted in the approval or disapproval of the American people. So that's my first question to Brennan. And second, I think I caught him in a mild contradiction. On page 372, he potentially contradicts himself when he says that judges can't know the intentions or original principles of the founders, but then he turns around and states what the intentions and principles of the founders were. So I think he does think that those intentions or original principles are intelligible, even though disclaiming that they are not. For Bork, I think this is what I would ask of him. Bork states that the judges must apply original principles to new situations rather than import new principles into the Constitution. Is this distinction so easy to maintain in practice? And it may be that to some degree you are claiming that you're not turning yourself into a founder when you're applying the founder's principles, but rather you're simply representing the principles embodied in the constitutional system on a limit. And by the way, both Brennan and Bork would say that you do have to operate as a check on the majority, because sometimes the minority is oppressive to the minority. We saw that, by the way. That is part of the framers' thinking. So again, as I would say to Brennan, you understand that in the framers. We understand that the framers all thought that sometimes democratic majorities could be unjust. that they can tyrannize the minority. You have to protect individual rights and majority minority rights. Hamilton says that. But then again, it's not clear to me that Bork can maintain this clear distinction between applying original principles to new situations versus applying new principles. Let me use as an example the difference of opinion on a controversial question, and that is the constitutionality of the capital punishment. In 1972, in the case Furman v. Georgia, the court declared the death penalty unconstitutional. Now, there was no clear majority opinion. Here you had a situation where there was a majority of votes to overturn the Georgia death penalty statute, but there were really quite different understandings of why the death penalty had become unconstitutional. Justice Douglas argued it was because it become racially applied racially unequally. It was a violation of the Equal Protection Clause. Justice White argued that it had become since cruel and unusual, and that, by the way, that was the text used as the constitutional text to overturn the death penalty. That the death penalty was constitutionally cruel and unusual. That's the language of the Eighth Amendment. Now, you don't have to be a Supreme Court justice to know that the principle cruel and unusual is a flexible or potentially vague principle. And basically, Bork Brennan, who was on the court, by the way, and participated in along with Justice Marshall, Thurgood Marshall, not the original John Marshall, but Thurgood Marshall, the first African American justice on the court, who, by the way, was the lawyer representing Linda Brown in Brown v. Board of Education in 1952. Lyndon Johnson eventually appointed Thurgood Marshall to court, and he was one of the famous liberal, I just use the language I don't like to use, one of the activist judges. When it came to the death penalty, those who argued, this was Brennan and Marshall's and Blackmun's, by the way, opinion, that as a nation we now know that the death penalty is wrong. We have evolved so that even though the language of the Constitution allows the death penalty, after all, the Due Process Clause in the Fifth Amendment and the 14th Amendment says, nor shall any person be deprived of life, liberty, or property without due process of law. What that means, of course, both in the 14th Amendment, the 15th, and the Fifth Amendment, is that you can take somebody's life away if you do it procedurally correctly. After all, to deprive somebody of life, liberty, and property with due process of law through a trial means you can fine them, you can put them in jail, you can take away their property, their liberty, and their life. So the language of the Constitution clearly means that the framers thought that the death penalty was not intrinsically cruel and unusual. But that's what Brennan and Marshall argued. And in a way, the more telling opinion who supports this Brennanian jurisprudence was Justice Marshall, who said, yes, it's true that if you took a public opinion poll, like 80% of the American people support death penalty, and 39 of the states, 50 states, a vast majority have death penalty statutes. So who am I to say that the American people don't think that the death penalty is unconstitutional? There's no evidence of that, either in public opinion polls or policy. And Marshall says, well, but if the people knew what we knew, they would oppose the death penalty. Well, isn't that a little arrogant to say that I know better than the American people do what they think? So the other side, Bork's side, and by the way, this eventually came to be the court's opinion because they overturned Furman in 1976, and the death penalty is constitutional again. Although the question is whether or not certain modes of execution are cruel and unusual. But Bork would have argued, I'm sorry, the language of the Constitution is clear, the framers approved it, and that if you think that the American people have really evolved to the point where the death penalty is morally appropriate, there is a mechanism called amendment. The American people can update. The American people can pass an amendment which declares the death penalty unconstitutional. So there you have this great debate about what the task of judges is and how they should operate and what the scope and nature of judicial review is. And this is likely to be controversial, not only now, but in the coming decades. Let's close this discussion with a discussion of what kinds of constitutional checks and limits do exist on judicial power, and there are three that Wilson discusses, so let's give a brief discussion. One is congressional legislation, especially over the appellate jurisdiction of the court. Article 3 in Section 2 says that the Supreme Court shall have original jurisdiction. This is the case. This is the issues we talked about in Marbury v. Madison. That the court shall have original jurisdiction in where ambassador, or public minister, or consul, or a state is a party, state of the United States, and in all of the cases, the court shall have appellate jurisdiction, subject to the regulation exceptions as Congress shall pass. So the Constitution is explicit. The Congress, through law, can shape, limit, expand the court's appellate jurisdiction, which determines what kind of cases. Also, sometimes the Congress has passed legislation in the wake of a congressional decision to modify the scope of a Supreme Court opinion by passing just regular legislation. So there's no question that Congress can, at least through its legislative power, moderate or limit some aspects of the court's power. Presidential appointments and senatorial confirmation, as we saw. Although, also remember, as we saw with respect to Chief Justice Warren, presidents can't foresee how lifelong appointees on the court shall, how they will eventually behave 10, 15 years down the road. So even though presidents can shape the orientation of the court somewhat, after all, FDR did, President Trump did in his 3 judicial appointees, has no doubt appointed judges who probably will change the orientation of the court. But that's not a given guarantee. And some senators don't feel comfortable simply agreeing or disagreeing with justices, with nominees, based on their agreement or disagreement with their judicial philosophy. The last kind of constitutional check that has some potency is, as I've already mentioned, is constitutional amendment. Now, both Bork and Brennan admit that the people can finally speak authoritatively with respect to interpretation of the Constitution by passing an amendment. And here are 2 clear examples where the people spoke in response to a Supreme Court opinion and where a constitutional amendment overturned a Supreme Court opinion. Dred Scott v. Sanford in 1857, which held that black people could not be citizens of the United States, African Americans were not intended, and that Dred Scott did not become a freeman. That the openness to that opinion was the fact that the Constitution didn't define citizenship. So part of what the 14th Amendment did, passed in 1868, was to overturn Dred Scott. How? By providing finally a constitutional definition of U.S. citizenship. All persons born or naturalized and subject to the jurisdiction of the United States are citizens of the United States and of the state wherein they reside. So that decision overturned Dred Scott, and it made the 800,000 African Americans alive in the country at that time, right after the Civil War, immediately citizens of the United States, contrary to Dred Scott. Second, Pollock v. Farmers Loan and Trust in 1895 held that the income tax was unconstitutional because in Article 1, Section 2, representatives in direct taxes that fall directly on individuals as opposed to sales taxes, which are actually taxes on a commercial transaction or a good, or import taxes or tariffs, which fall on a product rather than an individual. The Constitution says direct taxes and representatives shall be apportioned in the states. And when the Congress first passed the income tax, they simply had a nationwide rate that was passed on all individuals in a certain income category, regardless of state boundaries or state population. The court declared the income tax unconstitutional. But in the 16th Amendment, the 16th Amendment overturns that decision and says the government can pass taxes on any kinds of incomes at once at any rate they want. So there are checks on unlimited judicial discretion in our system, as in general, all the branches of government and the states themselves are subject to constitutional limits and checks and balances.